So the subject of my paper is on idea submission policies, and I'll get into that specifically in a second. But to start off with, two previous articles that I did, one on case studies of patent assertion entities, and the second on a case study and analysis of the eBay Merc Exchange history, seem to revolve around this timing of communication where an inventor wants to commercialize a product and an operating company seems to want to ignore that or infringe it or something else. So that's kind of the background of what led me into this research. And what I focus on here are idea submission policies, which are processes for third parties to submit technology-oriented ideas to operating firms. And there's a lot that's involved in idea submission policies, including trade secret issues and misappropriation issues. But what I'm focusing on here are submissions of patented or patent-pending inventions and strictly policies for operating companies associated with third parties who are not employees, so nothing affiliated within the company itself. And the background from the patent system perspective here is that what we're looking at is to hopefully increase efficiencies within the operation of what the patent system intends in part. So including the disclosure and dissemination of inventions and specific inefficiencies that are within our current patent system as far as the commercialization process goes. And the question here is, can bad idea submission policies result in these inefficiencies? So the previous work that's been done recently on this kind of falls into three camps. So first off, a recent paper by Haber and Orfel related to the reason why inventors actually transfer products and partner with non-practicing entities. And they discussed these asymmetries in financial resources that essentially lead independent inventors into the backyard of the intellectual inventors or other large aggregators in order to actually commercialize their products. Another recent paper by Mark and Robin finds that few patent licenses that actually come from NPE litigation or just patent litigation generally results in any sort of new operation. Essentially, the licensees are just paying for what they were already doing, which is somewhat to be expected given that it's an infringement issue. But then lastly, we have this recent NBER study that finds that almost 50% of American operating companies, and these are manufacturing service sector firms, but technology-oriented, are actually reporting that their greatest source of new ideas comes from outside of their firm. So kind of a question here as to whether or not all of these results are incompatible or whether or not they do exist in harmony and it's just more about a timing issue. So that's where we get back into the idea submission policies. So if we assume that all the research assertions are correct, I think that it's necessary to understand, potentially change, how it is that certain firms operate as far as communicating with third parties about outside inventions. And the goal here is to essentially allow for greater expressions and communications to occur, to reduce the costs of the communications and the inefficiencies in order to potentially reduce patent infringement issues, increase commercialization, and other things. So, as part of the study, I started gathering data on large technology companies in 4 specific industries. So, automotive industries, computer hardware, computer services, and pharmaceutical. And the goal was to find different industries that are unrelated so that there wouldn't be overlaps, and then also to compare data on other things within the data that I gathered on the idea submission policies. So after the 4 industries were nailed down, I found the top 10 firms in the technology fields, and then determined through the help of research assistants whether or not firms can be categorized as having an idea submission policy, which I term ISP, or an NIP, a no idea policy, where inventions should not be submitted and there should not be any communication with outside third parties about outside technology. And the goal of this was to compare the ISPs and the NIPs in the industries to see if there were trends, to look at litigation between the different industries to see if there's any kind of correlation there, to look at the number of patents in industries, and to kind of analyze why it is that these industries might have different operations. And I'll note here is that this is not an empirical study for causation, so I'm not making any solutions to the troll problem or anything like that. Just kind of looking at an understanding and coming up with some descriptive data that we can find. So before we get into the specific results, I just wanted to kind of talk about some preliminary trends that develop. So it turns out that there are, or at least seem to be, standards within the given industries that we looked at. Generally speaking, automotive and pharmaceutical industries have ideas that welcome the submission of new ideas and inventions, whereas computer hardware and computer service firms actively communicate to outside inventors that they should not make contact and that they should keep their ideas and their inventions to themselves. It also turns out that international companies seem to be very adverse to having people communicate with them about ideas. And to get into just some sample specific language, again, right before we look at the data. So here's an example of General Motors policy, and this sounds pretty nice. General Motors has a new device section. This provides our customers and friends who are not General Motors employees with an opportunity to submit ideas, inventions, and suggestions. And it turns out that they also recommend further down on the website that you look at your patent options, that you communicate with an attorney, that you make sure that you protect your idea, and then you communicate with them. So a very welcoming message. On the other hand, Apple, and not to single out Apple, this is just a sample that's very similar within other companies in the same industry. Apple or any of its employees does not accept or consider unsolicited ideas, including ideas for newer improved products or technologies, product enhancements, processes, materials, yada, yada, yada. And then it goes on to say on the web page that if any idea is communicated either through the website or otherwise, the idea can be used by Apple for free on a non-exclusive license for Apple to do whatever they want with and to not pay the person who submitted it. So a very unwelcoming message to an outside inventor for sure. So if we look at the data, we can see again, automotive, for the domestic automotive companies, they seem to be very friendly, similar to the General Motors position. All seem to have idea submission policies. In contrast to that, computer hardware companies, for the most part, generally have no idea policies. Again, computer services companies, no idea policies. And then lastly, the pharmaceutical companies, mostly idea submission policies. And then if we look, and I note actually thank you to Laura for helping me out with Google on the computer services company there. It was good to sit next to a Google employee at lunch yesterday. And this is still preliminary data, so don't hold me to it, don't cite it or anything like that, but I'm working through everything with 2 research assistants now. So then lastly, if we look at some of the litigation data, this is data from 2013, 2014, Lex Machina. These are the top 10 defendants in the most new cases for both years. It turns out that there seems to be a trend that all of them have no idea policies, or at least for the most part, so 80%. And if we look at other top litigants, they all have no idea policies as well. So what can we learn from this? Well, first off, and then I'll just say lastly, that these trends also note individuals who generally have the highest number of patents. So I think that that's definitely a correlation, not to single out certain industries, maybe too specifically, but the industries in computer hardware and computer services do have a much larger number of patents than automotive or pharmaceutical, as can be expected. So I think the policies somewhat relate to the number of patents and potentially the number of kooky ideas that could come in the door and just the resources associated with those. But again, still working through the data on that. So, but generally speaking, and we're just looking for trends and correlations here, is that it seems that areas of no idea policies are also hotbeds for increased patent litigation. So again, the number of data or the number of patents seems to relate to the types of policies the companies have, and that also seems to wrap in with litigation. So in finishing up the data analysis of comparison for the amount of patent litigation versus the policies of patents within each group, again, I think all that relates together, but it certainly seems to have an increase. So the concern here is that do the no idea policies relate or potentially result in litigation for the certain types of industries? Well, there's certainly not causation that can be drawn from it. However, and this is kind of the thesis of the article, is that if the only way to knock on the door of the company in order to submit an invention is to serve a demand letter or to serve a district court filing, well then we're going to see an increase in demand letters and an increase in district court filing. So there should be another communication door that's open. So I think the recommendation trends from the article is that if we can have changes in the ways that companies can communicate with third parties and can communicate about inventions and patent protected or patent pending protected ideas, then hopefully we can take part in reducing some of the financial asymmetries that exist between individual patent owners and large operating companies. We can increase the commercialization of new inventions generally, and we can increase commercialization of new inventions at an earlier time period than would otherwise happen by actually filing some sort of a district court litigation after some infringement happens, and then generally speaking is decreasing the likelihood for an operating company to actually infringe if that communication can happen sooner. So with that, and since I know that I'm 3 minutes before lunch here, I will end, and I would love to have any and all thoughts on this since it is at such an early stage. Yes.
It's really interesting. Have you looked at what these policies provide? Because there might be much less difference between the companies that welcome idea submissions and those that don't when you look at what the policies provide. It might be, I teach an old case called Van Rensselaer versus General Motors from out of Detroit, where it's like they have this idea submission policy that sounds very welcoming, but it says it will only accept, these are our terms, and the terms are very similar to what you described for Apple. We're not taking anything in confidence. There's no confidential relationship. If you don't have a patent, screw you. We won't return anything to you. We won't
That's
tell you
been the auto industry's actual policy.
So they
forever, unless they just changed last week.
So it might be that they look less different if you read what they say.
Well, so in order to classify, and this is kind of getting into specifics, in order to classify as an idea submission policy, the company has to have an opportunity for communication, so either an email address, a mailing address, or an online web portal. It has to not give any indication that no idea will be reviewed. And it cannot have any language that says that submitting an idea will result in a free, non-exclusive license to use the idea. So I was very generous in creating an idea submission policy. But that said, looking at industries, and I think that I'm really trying to get into the history of the automotive industry, because right now, all of the large US domestic automotive companies have glowing websites that say, hey, submit us your ideas. We want to hear from our customers. We want to hear from outside inventors. And we recommend that you get a patent, and we're happy to pay you.
Submit something. Historically, when you submitted something, they would send it back and tell you, you better patent this, or they wouldn't read it. Somebody did it to Chrysler or somebody years ago,
right,
where they had this great idea that if you did something, it would improve gas mileage. And the something was that you reduce the weight of the car. And that set it off, and that was the end of the free policy. Now maybe it's changed with the internet, and maybe they've got a new policy, but I would try it first. Submit it. Find out what their real policy is.
All right.
Don't read their website.
Yes, sir.
I actually have a really long background in this because I used to deal with it in practice and went around California on a road show with the general counsel of Clorox, and he would tell a story how people would routinely call Clorox and say, I invented Clorox. I mean, for 100 years of the history of Clorox. But anyway, a couple of thoughts is, first of all, the open innovation literature, might explain why some industries are opting for a invention submission policy, some aren't.
Yeah.
I can give you more details, but the no invention policy, what that is all about is the prevention of an implied duty of confidentiality. That's what that's all about.
Yeah.
And the implied duty of confidentiality may appear to them in breach of contract claim, not
Yeah.
necessarily a
And
transfer.
I'm trying to separate out that issue.
Yeah, so, and then finally, I'm guessing that the companies that have an invention submission policy also have set it up with a clean room kind of environment, where if there's ever litigation later,
Yeah.
they can prove that what they ended up patenting
Was
wasn't
wrong.
tainted by what this thing was. So-
Yeah, there's, I mean, so I get into all this detail, looking at all of the ideas, all of the litigation cases in the last 20 years that relate anything to idea submissions, and there's very few that relate back to this, but yeah, when you separate out those things, there's seemingly no reason for a company to not allow it, so, yeah.
So there's a book by Jeffrey Leichert called The Toyota Way, and Toyota has had this long history of letting its employees submit ideas, not only for their work, but also for cars. So to the extent that you want to use a counterexample of what the U.S. auto industry has done, I think that book would be really
Is
helpful.
that for employees though?
Yeah.
Okay, yeah, so that's a separate issue, so there's no, yeah, so lots of companies have that. I know when I was at Hewlett Packard, they had, perks for engineers that could come up with ideas and got patent on all sorts of things. But thanks, I'll take a look at that. Tim?
So, Sharon's kind of made me wonder a little bit of, these are, I assume, are operating under a backdrop of state law, right? And so, what are their choice of law provisions on this? Do they get into that or not? Because I would think that how they articulate what their disclosure, what their obligations are, may depend on what state are they in and what kind of implied statement, right? So I'm just wondering if you've tried, I know you're not doing control regression analysis, but
Yeah.
that might be something else to
So-
think about. Like, what is the background state law with which this particular company is operating?
So any company that has an idea submission policy separates out all those issues. So it says there's absolutely no contractual obligation that's being created here, and there's absolutely no thought of confidentiality that's being created. And in fact, anything that you submit will be distributed out widely.
But my main point is, going a little bit to Becky's point, if there are differences,
Okay.
what they may be trying to account for is implied confidentiality, right? And that may be a creature of state law, so that may be impacting how they're articulating some policy. It's getting into the weeds a little bit, but so that might be some of the story. So maybe somebody's a no submission place, given the way that the state will infer their obligations. So just maybe another wrinkle to look at.
Okay.
Yeah, just two industries that you might think about. Because those are all very techy industries you have, but the toy industry, this happens all the time, right? And there's this famous case about Tornado Taz, the Tasmanian devil toy, and whatnot. All the toy companies have policies and they invite submissions, and of course Hollywood, right? On the copyright side, there's a ton of litigation around this, and there are all sorts of norms that pervade the industry, that studios all have policies that are quite aggressive, just like this, but they still pay people who pitch them ideas that they use for shows or movies.
Yes, so in the paper I go into the movie industry and then also the publishing industry and what they're doing for movie ideas and then copyright issues.
So one of the things that jumped off the presentation that you said to me was that you were talking about who's submitting these things, and you mentioned that it was sometimes people like sales or marketing. It wasn't just users. And then some of the companies that you had up there with no policy looked to me like they were highly integrated and vertically integrated companies. So Apple is an example of that, right? Where they're enormously vertically integrated. So they're actually getting that feedback. It's just all in-house. Because there is a big literature that a lot of your innovation comes from coordinating with your, the manufacturers. It's the people who design coordinating with manufacturing, people who design coordinating with sales, getting that kind of feedback. And so it may be that that's also what's happening here, is that we have vertical integration.
Absolutely, although, and we have a Google person here, but I note that Google does have a fairly strong idea submission policy that takes all these points into account. And in support of our lunch, that I think is being partially sponsored by Google coming up, I'll say that it's a very impressive policy, and it kind of lends itself out as a useful light for other companies to model themselves by and say, well, why is it that you're sticking your head in the sand with respect to third-party innovators? Is it really required?
One point on that though, what would be interesting is to also look at terms of use agreements separately.
Yeah.
For user generated content, because I think their policies are inconsistent. For user generated content, they say nothing, but they have no duty of confidentiality. So that's a problem with a lot of.
Great, thank you. Well, on that, thank you so much.